Thomas Welsh. Councilman Ballard. Dan Mancuso.
Here.
Guy Murata. Lou Demento. Barbara Boas. Art Murphy.
Here.
Juanita Lewis. Dave Cassidy.
Here.
Fred Stone.
Here.
Eric Perry.
Here. Let the record show that Juanita Lewis is entering the room. We have two quick administrative matters, the approval of the minutes for September 16th. Do we have a motion?
So moved.
Second.
All in favor?
Aye.
Any opposed? Approval of the 2020 meetings for that?
So moved.
A second? All in favor?
Aye.
Any opposed? Great. Our public hearing, 176. Well, we can make Mike's eyes while we wait for Ed.
But before we do that, I want to see who's eligible to vote.
Let me introduce first. 176 Riverside LLC, Block 3, Lot 201, 401, 6, and 901 for preliminary and site plan. Final site plan approval continued from September 16th.
Hold on, Mike, hold on. So we have three open?
No. Eric is the mayor's representative.
Eric is the mayor's here, so he will not be voting.
Yes.
Yes, he will not be voting. Okay. Now, are there any members who are missing?
Dr. Murata is missing.
Dr. Morales, so who is alternate? One?
David is.
David is alternate, so he will be. If we come to it. All right.
Thanks for coming in, Dave.
Eric, run now while you can.
So
So we asked both council to give us a brief regarding the driveway curb cuts, so Mike is going to summarize
Yes.
those for us now.
I have to first of all compliment both attorneys because it really is really studious and the type of brief that you would submit to a court. I'm not that high elevated, so I am really impressed by both attorneys and their and the depth of the legal arguments that they provided. I think the first one we received was from the applicant, from Chad. Basically, he carefully demonstrates that by case law, that we do have the power, if it's granted to us, to grant C variances, and only D variances are prohibited. And therefore, if we determine that the curb cuts are in excess of what the plan requires, and that's the determination within itself, that we have the power to grant a variance or a waiver. Mr. Gazarovski, brief, doesn't dispute now that we have the powers to grant C and C variances or bulk variances and waivers. And I think his position would be that if, for instance, the setback required was 10 feet and it was 9.5 feet, we could grant a variance if it's under the usual standards. They have to have certain proofs for the half a foot because of certain technical reasons. Let's say we were saving the tree or something like that, and we had the power to do that. But when Mr. Gazarovski says that there are certain parts of the plan which are crucial to the plan, and he points out, for instance, that if the applicant had come in with an egress or an exit on Riverside, that would be counter to the very core, it's a core requirement of the plan, and that we could not give a variance for it, even though it's not a use variance. We could not give a variance for that because it's so much to the core of the plan. And I agree that that's a good point and that he's right about that. However, the question is whether or not that translates to Bodman Place and the number of driveways, and whether or not the number of driveways is within both properties or the way the plan describes it, only the property that's the subject of the application. And that being it, it's basically, in my view, the board's determination of whether or not the driveways, one, are a violation, and number two, if they are is it a core requirement, or is it something that we can give a waiver or a variance to? I think that sums up pretty much what is said. You want to add anything?
If I can, what I pointed out in my response to Mr. Gazarovski's brief is the governing body made a determination in the plan as to what the planning board, kind of variances the planning board can and cannot grant. And Mr. Gazarovski mentioned these core requirements. He was citing the section of the plan what talked about for the procedures if in fact the governing body decided to modify the plan. So if the board, if the governing body chose to modify the plan, and when in so choosing to modify the plan wanted to change a core requirement or a land use requirement, that they would have to provide public notice and move forward in that way. What Mr. Gazarovski fails to point out, and which I pointed out in the reply brief, is the governing body also, when they did the redevelopment plan, pointed out and said you can give C variances. It didn't make any requirements as to what C variances you could grant, what C variances you couldn't grant, but it said specifically when a deviation from the plan required it to go back for an amendment, and it specifically said if a D variance was being sought, that was the circumstances in which it has to go back to the governing body for the governing body to make an amendment to the plan. This is clearly not a D variance situation, which would mandate it going back to the governing body for an amendment to the plan.
But what you're saying is the law anyway. The governing body. The governing body could not override the issue that you cannot give a D variance to the planning board or board of adjustment.
Well, under certain,
Let me finish here. So that what you're now saying is fundamental to the redevelopment plan. The real issue is, and I have to agree with Mr. Gazarovski, and I think you would too, that if you came in and said that you wanted to put a driveway on Riverside, that you couldn't do it and that this board couldn't approve it. Is it your position that we could approve that?
yes, because it's not a D variance.
Well, I don't agree with you as to that. I think the answer really is whether there are certain things that are so core to the application that I don't think we could grant a variance to put a drive. That's my view. You could not put a drive on Riverside, because it specifically says in there shall not be any access from Riverside. It's right in the plan. How could we then grant a variance after it specifically says it's a core requirement?
And again, I'm saying because the plan gives you the power to grant C variances. But that being said,
That's my view. But I do think that it's a big difference between what's on Bodman, there's a number of driveways, and an access through Riverview.
and I would agree with that, that we're talking about a design waiver with respect to the number of
Okay.
driveway access on.
Mr. Gazarovski, or I see he also has co-counsel there, a very important co-counsel.
Let me, good evening, members of the board, Mr. Lexing. Thank you for the compliments you afforded to both of us with regard to this
It's
issue.
true, they're very good.
Good, and I think the last, say, 30 or 60 seconds of this give and take with regard to your pointing out how Riverdale would not be something the board had the power to grant, but they can.
Riverside.
Riverside, rather, sorry. I discussed this at great length with Mr. Riley, who did in fact contribute a great deal of the thought process to this, and I'm going to yield the floor at this time for him to put forth the position of my client.
I promise not to be long-winded.
Okay.
I think,
Yeah. And again, identify yourself.
Bernard Riley, I'm, work with Mr. Gazarovski on a lot of zoning matters, and,
Mr. Riley, please just pull that mic down a little and closer to your mouth.
okay.
Thank
That's
you.
better? Thank you.
He handles
Yes.
anything that requires.
Anyway, I think the problem with this case is they've gone about it wrong. The applicant has gone about it wrong. if you look at the map of the zoning, of this redevelopment plan area, it's not a big area. It's relatively compact. And it obviously, I think everybody, and I've been in this town a long time, everybody knows that's a very unique area, and it's a very difficult access area. And so it seems to me, and it's pretty evident to me, that the council, when it decided, okay, fine, we're gonna do a redevelopment plan, well, there's a purpose for that. The purpose is really so that we can limit access to a couple of spots in the plan area, and this is gonna be developed all together in a redevelopment plan. The whole entire tract should be developed together. The applicant has chosen not to do that. Now, the applicant has a right, they can either go under the existing zoning, and they can go out, they can access out to Route 35, they could access out to Riverside, they're free to do that. But no, they decided, and I think the intent of the redevelopment plan was, let's not let them access out there, let's give them some kind of zoning benefit so that they will develop the entire tract in accord with the redevelopment plan. Not leave a hole out in the middle of the donut and say, that's gonna be developed somewhat different. The whole tract should be developed together in a common idea. And that's why the redevelopment plan says, okay, if you're gonna use the redevelopment plan, you can't go out on Route 35, you can't go out on Riverside. The only thing you can do is you can go out, you gotta have 2 driveways, maximum of 2 driveways for the whole zone out to Bodmin. That's the way you gotta do it. That's the core design concept. You can't go out that way, you can't go out to Riverside, you have to go out to Bodmin, and you can only have 2 access points, and that's gonna be the access points for the whole area. Not that my client, who has the hole in the donut lot, that he's gonna develop it someday on his own. That's not the intent of the redevelopment plan. The intent of the redevelopment plan is it's all developed in a common plan with the core design concept being the access. That's the key to the whole thing. And that way, I mean, frankly, when you first look at this, and I frankly wasn't even involved in this, I was reading about it in the paper, I'm thinking to myself, what kind of idea is having a redevelopment plan? Because why isn't it done to the regular zoning? Well, when you think about it, it actually makes a lot of sense. I mean, I think the council actually probably thought this through, and it makes a lot of sense. Yeah, you're giving up something if you go under the redevelopment plan. You're giving up your rights to go out to Riverside, go out to Route 35, or just require a piecemeal development with multiple access points on Bodmin. That's what you're giving up. In exchange for that, you get this high density, high intensity right to build. So there's a benefit, there's a burden. The applicant should have made his peace with the hole in the donut. The whole intent of this is not to develop lot by lot or structure by structure or with driveways like a cookie cutter type of thing. The whole intent of this is to have a common plan for the whole zone. That's the way it's supposed to work. That's the way you'll come out with something that's legitimate, and it's not going to be some kind of disgrace or more unsafe than it probably is going to be anyway. But at least you can say we address this in a common, logical way, and that's why we're doing it this way. And I think the council, if you read the logic behind the whole thing, that's what they were trying to do. And again, it's not mandatory. They could develop it lot by lot, like the common thing. People come in with a lot, they develop it. They could develop the property that fronts on 35. They could just develop it. We own this lot, so that whatever name it's in, we want to go out to 35. They have a right to do that. It's only when they decide to go with the redevelopment plan that they got to adhere to the core development concept, which is the access. That's the key to this whole plan. If you don't adhere to the access plan, you're not adhering to the plan. So our point is that's the way it works. And frankly, if you don't do it the way it's supposed to work, then you're not following the plan. And the plan is to make this develop as a whole piece of property, not where they're coming in piece by piece, lot by lot, driveway by driveway. That's all I have to say. I think if you analyze it and really think about it, and frankly, I thought about it a lot before I realized how this is really supposed to work, and what the benefits are, and what the burdens are, and what they really, how they've approached this in the wrong way. So the whole approach is wrong. Thank you.
Thank you. And if I may just briefly, I first point out, we don't own that piece of property. It's a non-condemnation redevelopment area. We have no rights or ability to obtain that piece of property. The redevelopment plan talks about applications for development, which are a defined term in the municipal land use law. The applications for redevelopment, or the application for development, is governed by the developer's choice, and the developer is the person who made the application, the owner of the property. They can choose either the redevelopment standards or the underlying standards. We've made the application for the property the applicant owns under the redevelopment standards, which has the 2 driveways on Bodman Place. That is the application before you. We have no ability or authority to bind their property. If they wanted to develop their property, they'll make their own application for development, and they can choose whether or not to do the underlying zoning or the redevelopment zoning. If they go through the redevelopment, I note that their property's undersized, but again, it's an optional overlay zone where the applicant has the choice to move forward one way or another. As to the standards, well, Mr. Lexington and I disagree on the one point. I will point out, this is clearly a design issue, a design standard as to the number of driveways coming onto there. The core of the application is the fact that it's a large apartment complex with commercial uses. The property, all of the access is coming through Bodman Place as required. The board clearly has the authority, if they believe a variance or a design waiver is appropriate or is required, the board clearly has the authority to grant that under the clear language of the redevelopment plan.
My only responsive comment is, yes, they can condemn it, they can negotiate. That's the way a lot of things are resolved. You can negotiate if you have a need and my client has a need, because otherwise it's boxed in with this thing, because as I understand, it's pretty much right on the property lines. So what's he gonna do with his property? You negotiate. That's what should have happened here. They negotiate, and that's the point. If you wanna use the redevelopment plan, you gotta negotiate a plan. Thank you.
Anyone from the board have any questions regarding this issue or the brief submitted?
Mr. Chairman, I just want to add one comment that I have. There was some representation made about access to the state highway. It's been mentioned.
For clarification, you're talking about Riverside Avenue, is that correct?
Either Riverside or
Or
Route 35 going across the bridge. They're both technically the state highways.
And it would have something to do with the state of New Jersey
DOT
might have
with-
something to say about that.
With dual access on a local road and a state road, the state generally will not allow you.
Of course
That
not.
was,
Of course
in
not.
theory, my belief is that's what was intended
Whether it's
there.
whether it's in the redevelopment plan or not,
They would never
the
get to
DOT
drive it.
would never have allowed it.
Correct. I just wanted to
But
add that for clarity.
they do strange things
Wait a minute,
once in a
time out.
while.
If I may, can I comment in response to that?
Sure.
These were different lots. If you look at the plan, this was made up of several different lots. At one time, and presumably maybe even now, they're under different ownership. And so the lot where that gas station was on the corner of 30, that had access for years. That was a separate lot. It could have been developed, probably still could be developed. And it doesn't have access to Bodman. It's a separate lot, as are a lot of lots. They're all separate.
We're not gonna speculate what the state will do.
We're not sure what piece of property you're talking about.
Because I don't think that's part of the
The
plan.
one where the gas station is.
Right, but that's not on this property. It's not subject of the redevelopment zone.
I thought it was.
Not this gas station.
Huh?
It was a different.
No, I'm not talking about when this is the active gas station. It was formerly a gas station years ago.
But that's not part of the project designated.
Okay, let's move on.
Anyone else on the board with any questions?
Yeah, Mr. Chairman, just for the record.
Turn on your mic, Artie.
Am I to understand that both driveways are on Bodman Place,
That's correct.
correct? All right, thank you.
Well,
And
it's
just
just,
for one point of reference on the
Sure.
redevelopment plan, 2 acres was the minimum standard to qualify under the redevelopment plan, that's correct, right? And there are 2.4 acres,
I don't know the exact number.
roughly?
Roughly, yes.
Thank you.
I'd like to give anyone from the public an opportunity to ask any questions of Well, any questions specific to,
Right, there's no testimony.
yeah, if you have any questions specific to the issue we've discussed so far regarding these briefs, you're welcome to come up now. We will get to comments momentarily. If you've got any questions, you can come up. Make sure that's turned on, please.
And I guess I'm just,
Okay, Beth Lucas at 130 Apartment.
if I may, I'm just, so I understand clearly. Okay, that's what I'm trying to find out.
I do.
Very simply, if the public has any questions about what was just discussed, I want them to have an opportunity to ask them.
No, there was,
On a legal issue.
Yeah, only on the legal issue.
Yeah.
Yes.
it was brought up at the last meeting about having, it would be required to have an emergency exit in case.
We're
That's
only,
not-
we're only dealing with the legal issue we've
Okay.
discussed tonight.
Mr. Chairman, can I have a clarification as to one thing as Board Member Murphy brought up? He asked if there were two driveways. If this plan is in fact approved, there will be 3 driveways, with each of those 1 driveways having an ingress and an egress, 2 of them to be utilized by this complex, and the 3rd one being utilized by my client for the parking lot. So it will be.
The argument has always been that there's 3 driveways as a result of your clients plus theirs. And that the argument is that the zone only permits 2.
And my client's property is in the
We
redevelopment
understand.
zone also.
We understand that. Okay, now.
Ladies and gentlemen, if this is your opportunity, if you have any comments regarding the application, please step forward. Mr. Steeper, come on up. We do need to just,
You've been sworn before, is that correct?
Yes, I
so
have.
you just your name and your address again for us for the record.
I am Peter Schkeeper. I live at 130 Bodden Place. I've lived at 130 Bodden Place for more than 28 years. Mayor Mena, Chairman Mancuso, ladies and gentlemen of the board. Increasing Red Bank ratables is good. Increasing Red Bank affordable housing is good. Increasing traffic problems is bad. Bodman Place is a dead-end street with a history of traffic problems. There are no provisions for a vehicle to turn around and exit Bodman Place without trespassing on private property. And it happens often. There are no provisions for emergency vehicles to access the people on Bodman Place when the entrance is blocked, and that does also happen. I never received any notice for meetings that occurred last December. Perhaps the affected public is not entitled to be presented at meetings where ground rules are changed to facilitate a developer. Had the public been notified, there would have been traffic engineering testimony indicating that New Jersey DOT looks favorably upon a traffic light when the redevelopment plan includes such a requirement. That you heard at a prior meeting. A grave disservice has been put upon the Bodman Place community. Bodman Place will not be safe until a traffic control light is installed at the corner of Bodman and State Highway 35, called Riverside Avenue. This board needs to take every legal action to delay approval until the traffic light is approved by New Jersey. A revised redevelopment plan may be necessary. Provisions for vehicles entering Bodman Place to turn around are needed. Provisions for emergency vehicles to enter and exit Bodman Place when the entrance intersection is blocked is needed. I recommend 3 proposed conditions for approval by this board after the traffic light approval has been resolved. 1, prohibit any staging or temporary parking of construction-related equipment on Bodman Place. 2, require a separate temporary entrance to the construction site from Riverside during most of the construction. 3, require full-time, 24/7, recording real-time video cameras posted on the internet for all interested parties to view, with one elevated camera showing the entrance to Bodmin Place and one elevated camera at the north end of the property looking south toward Bodmin Place entrance. The videos need to be saved at least weekly for future reference, and there needs to be criteria for unsafe conditions that will require a stop work order to be enforced by the police. Thank you.
Thank you, Peter. Anyone else have comments? Now's the time. Come on up. Just remind us who you are and where you live. I know you've been sworn.
Is this on? Okay. My name's Thomas Salmon, 130 Bodmin, number 3. 15-year resident, taxpayer. And I would like to just say, Mr. Mayor, members of the board, I'm angry. I'm angry about this. You know, everybody's all lawyered up, right? Everybody knows what's going to go down, but the residents, we get a certified mail maybe 2 weeks ahead of time. We have nothing. Who represents us? All right? The zoning was changed supposedly in December of 2018. Nothing. Crickets. Nothing. Right? We get nothing. The political stench is unbelievable. That we wouldn't know that our zoning was changed on our street is just ridiculous to me. The idea of a 210 rental monstrosity on 2.5 acres just doesn't make sense to me at all. It's 2.5 acres or less. You know, it's just, you know, where's the fair treatment of the tax-paying residents on Bodmin Place that we would have to get this? You know, and retail space on Bodmin? Look at all the empty retail space downtown. We need more empty retail space? You know, to me, this is just ridiculous. We don't need this. Traffic, okay. This always gets us down, right? We have a highly paid professional traffic expert come here and tell us that nobody waits more than a minute to get out of Bodmin Place onto Riverside. No one waits more than a minute. Anybody who lives here or works here knows that's just not true. You know, pretty much it's a lie. You know, but we have high-powered, highly paid professional people here telling us what we know is not true. It's just ridiculous. Then again, we have not, you know, addressed what's going to happen with the pedestrians. We have not addressed what's going to happen with school buses. Every time you ask a question, well, that's not for this one, it's for something else. You know, come back with that question later. Emergency vehicles, nothing, okay? Who's going to address all this stuff? You know, or we're just going to have to live with bad stuff, right? This needs to be addressed, and I want to know how and when. The architectural renderings, all right? I asked what would it look like from Bodmin, you know, where I live on Bodmin, when I look across the street. Well, there are no architectural renderings for that, I was told. I mean, that seems pretty inept to me if you're going to be blasting this thing in there. The landscaping. Bodmin is a nice looking street. You know, you look down, there's a nice tree-lined street. I ask what's going to happen. I don't get a real answer, okay? What do I hear? Rooftop gardens. I don't want to hear about rooftop gardens. I want to know what my street's going to look like when I walk down my street. To me, personally, this is really about greed. First, the developer wants to, you know, cash in. They want to maximize their dollar return. I get it, okay? Everybody wants to maximize their dollar return. The second part is that the politicians want to maximize their rateable returns, okay? And I get that. But the question to me is, which is worse? Because we're at the tail end of this, all right? The people have the least amount of representation. It's our quality of life. We're going to live with this day in and day out, long after this is done, okay? What about the quality of life here in this town? Why we moved here, why we live here, okay? So please, Mr. Mayor, members of the board, please bring this monstrosity into some kind of palatable situation that we can live with. This is just, we're just asking too much. You got to bring this beast down a bit. Thank you.
Thank you. Come on up.
Hi, I'm Maureen Mell at 138 Bodman Place.
Maureen, were you previously sworn?
The first meeting where we could ask questions.
Okay.
I wasn't able to attend the other couple of meetings. What I did want to ask though is, during that meeting, I asked about the parking spots that we have on that street. And I'm not sure if anything has changed since then.
Ed, did you answer that at some point? I recall that there is not a change to the number of parking spaces, but I could be wrong.
That's right, that's what they told me.
Right, I thought that's what the testimony was, that there was no reduction in the number of on-street spaces.
I believe that was the testimony.
So I just want to understand, when you say driveway, you're talking about you enter and then you exit, not from the same driveway. It's like, I thought from the renderings I saw, it was like a semicircle. You go in one way, you come out another. Or is it one way you go in, turn it around, and then you come out?
Chad, can you have the site plan put up, just so we can take a look at that, please?
The reason I'm asking is, there are 4 parking spots across from 138 Bodman Place that we were told will not be affected. But I went out the other day and took some pictures, and in trying to understand and overlay these renderings, I just don't see how it's not going to be affected and we won't lose that. And they're valuable to us, especially if you're going to bring another 210 units in, which could equal, if you think about bedrooms, almost 300 people, you know?
So you're talking about the west side of the street, the side of the street where the development is going to take place?
Yes, yes.
So Chad, one of your experts could please point out to us the parking spaces as they're there now and confirm for us whether or not we're going to lose any from the development. Yeah, sure.
This is Mr. Fruit, who's our site engineer. If I may, the question, we were provided by the neighbor right now a photo, and I believe, is this the areas that you're talking about?
These are the parking spaces right here. So I'm wondering where the driveways are.
Okay, so if you want this, is it objector, or how do you want it, public, P1, public one? Yeah, you can make your P1. P1. Pretty good. P1, I'll mark it P1 for public one. I'm gonna share this. I first note a lot of the curb appears to be yellow on it right now. I'm gonna provide it to Mr. Fruit. It doesn't show any parking, it's spaces, it shows a curb line, some of it, the majority of it appears to be yellow. To me, part of it appears to be white.
There were no cars there when I took the photos, unfortunately, to show that only 4 can really fit. Excuse me? Yes, yes.
Where it's marked yellow?
No, it's not yellow.
It appears down by the tree that was previously spoken at length about, below the middle driveway, closer to the office building. It appears that there's approximately 4 spaces there. They're not striped as parking spaces, but they're not yellow. So everything above that middle driveway is yellow. So I think there's only 4 spaces on that side.
And are they losing any of those?
Defer that question.
For the record, maybe you can answer this. For the record, are those borough spots or those personally belong to
Street parking.
street parking? Just regular borough and street parking?
Yes.
So help us out, Mr. Fruit.
Certainly. So again, it is, was just put out, these are on-street parking, they're not at all related to the site and the inventory of parking provided on site, or for that matter, any of the other developments along Bodman Place. Generally, the area, excuse me, we're referring to is from the north end coming around the curve towards the parking lot. Right now, there is a driveway
towards the south end, if you will, of this half of our frontage. And it's an area just north of there that does provide a few parking spaces. We are shifting our exit driveway further north from there, so we'll be able to replicate parking in that interim space between the two driveways. And we're also keeping parking between our two driveways. Anything further north, I believe, is identified in that picture as yellow striped, and anything south of that area towards the intersection is also yellow striped. So there's limited parking available now, which by the adjustment of parking can be replicated within the curb frontage. For
Short answer is nothing is being lost, is that what you're saying?
It's no net change in parking.
Shifted but not lost.
Correct.
So where the yellow is marked will now not be yellow, is what you're saying?
No.
No, I understand, but then I'm not following you, because when I take a picture here, this is the Colonial House parking, and I don't see where you're gonna shift these parking spots based
So right-
on my photo. I
Lloyd-
see your rendering, but I just don't understand where it's going to shift.
So
You have two
closer.
driveways.
I'm gonna try to answer for you. So here's the Colonial House driveway, the unrendered portion of this plan.
I mean the
This is
Colony
A-
House.
For the record, this is A2.
Colony House, yes, sorry.
Sorry.
Colony House. The driveway for the VNA is immediately adjacent to that property line. So by shifting our driveway access points further north, we'll just flip-flop that driveway with a parking space, and we'll still have spaces between these two driveways. So the net is the same, it's just shift a little bit on the frontage.
Bottom line is, if you are impacting any borough parking spaces, you would need the authority of the municipality to do so. But are you saying that whatever is public parking, then that same number will remain as a result of your development?
That's right, and again, I
You're just
don't-
shifting them, but the number will remain.
The approximate number is the same. These are not delineated, identified parking spaces. It's an area of frontage that is not yellow striped for no parking. And we have approximately the same amount of frontage there that would be available for parking.
Okay, I'm not quite sure. I guess we'll see it when it happens. I'm a little confused on waivers and variances. I understood when I first came here and we were listening to the lawyer speak. He talked a lot about, we have a waiver for this, we have a waiver for that. I'm not quite sure how they were granted all the waivers. I don't understand, how this happens. So I'm just curious what they were able to do to get all these waivers and not have variances that we could speak to, the public could actually, have concerns over. Because waivers we can't vote on or we don't have any voice on.
Well, you could comment on any of it, which is really where we are now. You can comment on waivers, you can comment on variances, and that's all part of the zoning plan.
My other question is, I heard that there's gonna be affordable housing. So I know that that's probably appealing to Red Bank. Or maybe it's something they have to put in if they put in new development. Is it right now, without this development going in, with the development we currently have, is there a quota that Red Bank needs to make and we're below the quota? I kind of, in conversations.
The short answer of that is all yes. Affordable housing is both needed and desirable, and the borough is under obligation to provide affordable housing, and this helps us get closer to where we need to be.
Okay. So the other development that went in, they didn't have the affordable housing, so we're making up for that? I'm just trying to figure out.
The rules were not in place when those developments were approved.
Okay.
So the law went in place after those developed. For example, the Colony House, I don't know how many units they have, but they are not a low and moderate income housing designated. And if they do have any lower priced apartments, we cannot use them legally in our inventory to meet the constitutional mandate because all of those units were built before the Mount Laurel decision. If we could use some lower income units that we have, for example, with garden apartments on Spring Street, we would not need to meet our constitutional mandate. but the way that the Supreme Court of the state and the legislature has crafted the law, anything built prior to the Mount Laurel decision, we cannot use to meet our obligation.
I would imagine though we were grandfathered in, right?
What was grandfathered in?
Well, at a certain point, you can't go back in time, right? You put the Colony House up and.
No, what I'm saying is that they didn't have the obligation. The obligation came in only after the Mount Laurel decision.
Right, Mayor, correct me if I'm wrong, I believe what happens now, any new development, a certain percentage of it has to be
20%
low.
or 15%,
Right, has to
yes.
be low-income housing, so that's how it works.
Yeah, that I understand.
Right.
What I was hearing through conversations is that we were making up for
No.
affordable housing that hasn't.
I don't think we can regulate that, it's the percentage that's being built that we have to put in low-income housing, so whatever that number is, it's what it is.
We have a number that we have to attain, and this helps in attaining that number, but that number is set by the courts.
The last thing is, just as some of the other folks have said, it's upsetting for this huge monstrosity to be put up on Bodman, which is a small street, it's a dead-end street. It's not very wide. And I think what concerns me is fire. You know, if there's a huge fire at the end of that street, what's the evacuation plan for us? How do you get us out? Is there gonna be a ferry? There's only one way. Has anyone thought about that? You're putting in 200 to 300 more people on a street. There's a fire. How do we get out? I'll leave it at that. Thank you.
Thank you. Anyone else from the public?
Ron Costello, 138 Bodman. I believe it is. You don't hear it?
No, here, close.
Can you hear me?
Yeah.
Good. So, Dr. Sam was talking about the 20 years resident. I'm a lifelong resident in Red Bank. I've seen it evolve. First, I want to thank the board for giving me the latitude in previous meetings to ask questions that went a bit far afield, perhaps. But thank you for that. When I ask questions of colleagues, the intent regarding that case is to have differences of opinion, but come to the truth of the matter for the purpose of providing a good outcome for the patient. I've heard varying degrees of truth at these meetings. Several relatively truthful experts, others biased, and some simply deceptive and lies. I've also been concerned by just a few of the responses of board members. The density of this project, and this is more than just this development. This developer has already built, I'm told, in town. There's been at least a half a dozen other large projects in town. There's the intent for the Hampton Inn at the north end of Bridge Street, Bridge Avenue, to have 80 units there. And there's also, I think, consideration. I believe there's already been a application for a potential parking garage at the Molly Pitcher. All of these projects, the density involved in our small community will lead to impossible traffic and pedestrian utilization issues, if not unwarranted, dangerous, and fatal events for both. Ultimately, roads may be built to bypass Red Bank, or drivers may simply pass around Red Bank in view of the anticipated traffic congestion, something for Red Bank businesses to contemplate. Mr. Mayor, you suggested that I contact DOT regarding a traffic light. Well, I made some inquiries and I realized that it's a catch-22. A light has been sought by your administration for about a decade, and for multiple years by the previous administration. The cost may far exceed $300,000 mentioned previously. More than once, the agents of the developer have emphasized that they are prepared to pay half that amount. Problem is, Mr. McCormick testified that the corner of Bodmin and Riverside is usually a Class A traffic situation, sometimes a Class C, and a Class F at morning and evening rush hours. We, as residents, are managing the current traffic conditions, but if this project proceeds, that will deteriorate. Mr. Warnken rebutted Colonial House's expert traffic witness in saying that he took a picture while showing a construction sign on Bodmin and claiming that it portrayed unusual adverse conditions for traffic that day. Gentlemen, ladies, the construction phase of this project, we're told, will be 2 years. By their own objections regarding that sign, the traffic will be a Class C or less during this period. And in my opinion, it will remain so well beyond those 2 years. A traffic light may help the situation and will be almost mandatory if this project proceeds. Therefore, since we are currently dealing with the traffic on Bodmin, but will be greatly encumbered by this project, I suggest that at least 80% of the total cost of a synchronized light at Bodmin and Riverside should be borne by the developer. The chairman of the board said he was inconvenienced by street work at his home street. I doubt that it lasted 2 years, and with perpetual traffic issues expected to persist, those problems will last indefinitely at Bodmin. The catch-22 is that the light has been sought for nearly 20 years, but the cost would be inordinate for the borough. Now a project presents that will absorb half the costs, none of which would be otherwise required except for this project, as per witnesses on both sides, except during morning and evening rush hour. Nevertheless, the Red Bank taxpayer shouldn't be on the hook for several $100,000 to make the developer's project viable. To my knowledge, there is no state prohibition to a light. None if the borough pays for it, and if it allows for the efficient flow of traffic. Worse, if a pedestrian going to or fro the train station or nearby abouts attempts to cross in the proposed striped gap, by New Jersey law, traffic in all lanes, north and south, would be required to halt. An untenable situation, and one the state would certainly come to oppose, and one that will eventually lead to serious injury or death. For if someone thinks a set of stripes on Route 35 is going to stop traffic going at 35 miles an hour plus, they could be dead wrong. Children darting from the proposed green area at the corner of Bodmin and Riverside can lead to a similar outcome. An ill-conceived location for that idea. One statement by their expert paid witness particularly irked me. Mr. McCormick testified that you can see cars coming when making a left out of Bodmin. In fact, if the queue is backed up from Ridge Avenue, even if a courtesy gap is offered, you can't see cars coming from the north on 35. Or sometimes, even those heading north on the inside northbound lane are not visible when you're at the corner of Bodmin. If, again, the queue on that side beyond to the east of Bodmin is backed up. Until your vehicle is nosed out to about the middle of the road, and then you're committed to either make the turn or hold up traffic going north. Again, a pedestrian, I don't think a cyclist is under the same rules, but a pedestrian crossing in a crosswalk would require all lanes of traffic to stop by law, a preposterous situation that will cripple the flow of traffic. This mammoth, hideous project, if allowed, should be contingent upon securing a traffic light at Bodmin and Riverside prior, gentlemen, to the start of the project. It was mentioned that curb parking on Bodmin would be mitigated. Mitigating means diminished, but not absent. Do you really think that 210 rental apartment units, moving in, moving out, people coming to pick them up, vans possibly coming to move, delivery trucks coming in for the retail areas, co-worker spaces that Mr. Warnken said would initially, in one of the earlier meetings, said would be time limited from 7 a.m. to 11 p.m. And in a subsequent later meeting said there'd be no limitation of time. You can check the record. Those individuals, there will be, for those individuals, daily pickups by an associated party on the curb, or by moving vans, or by delivery trucks. Not that the developer intended that to be so, but it will be the reality. Several years ago, it was cited in the papers that residents in the condominiums in our area weren't paying enough in property taxes. Well, if this project is approved, tax appeals from all owners will be encouraged en masse, since our quality of life will be adversely affected, as will our property values, especially regarding congestion and traffic issues and possibly unsavory smells from the prevailing westerlies, from car exhaust, from garbage coming vented up to the roof, from local dogs being walked in the area. There's been no comment on impacts of air conditions or pollution that I've heard, and I thought we were going to have an opportunity to ask additional questions, but we're suddenly in comment. I think that's something that the board should consider. Who do we turn to if our utilities are disrupted? The answer is an expensive attorney. Who do we go after? Well, that should be dismissed with a bond mandated by the board set that repairs and recompenses us for any loss of our utilities, be it phone, be it water, be it electric. And yes, electric is primarily on the other side of the street, but with building, that could be come to have a problem as well. I've been told that all these meetings amount to, by a couple of individuals, nothing more than a dog and pony show. I sincerely hope enough board members are addressing the needs of the borough of Red Bank, and present this hideous project as envisioned, prevent this hideous project as envisioned going forward. Those that are not already committed by backroom conversations or other intrigue that has led to this point. One last comment. I asked at a previous meeting who would be responsible for hitting a child or any person crossing that street. And of course, the driver would be at fault. I intend, if that occurs, to have all interested owners and renters in our community to proceed with a class action lawsuit in their interests and those of the injured party, and to sue the developers and this board, which represents the borough of Red Bank, for at a minimum, not anticipating the accident and properly protecting the public good. Thank you.
Anyone else in the public have a comment? That's it? Make a motion to close the public portion of the meeting. Do we have a second?
Second.
All in favor?
Aye.
Any opposed? Mr. Warken, do you have any closing comment before I throw it to Mr. Gazarovski?
Of my understanding, Mr. Gazarovski is going first.
Okay.
You have one closing statement? No, this isn't.
Mr. Chairman, members of the board, Mr. Mayor, I do a great deal of this type of work, meaning land use work, where oftentimes I represent individuals or entities that are opposing a particular project. But I want to make absolutely
Hold it a little closer to your mouth, please. We're not picking you up completely.
right. What I want to make absolutely clear, and I've listened to some of the comments of the public, and although they may believe it, and all those comments may be well-meaning, I do not attribute any wrongdoing or nefariousness to the members of the governing body, which is your legislative board, nor do I to this board. I may not agree with you, and I may not agree with perhaps what various government authorities may do, because I'm basically a contrarian. I've known my good friend Mr. Mehta for many, many, many years. And I'm sure that when he was a young boy, he was the guy they picked to do the collection in church because they knew he wouldn't take a nickel or a dime. And I think that's true of everyone who was on this board. And I would compliment you for your service. Going to this issue of the redevelopment ordinance, that is a legislative act on the part of your governing body. This planning board, nor does the Board of Adjustment, have the jurisdictional power to legislate. Only the governing body can. Now listen to my good friend Mr. Warrington speak in terms of seeking a waiver and or variance, and I would submit that that is a misplaced argument, because when you're making that argument, whether you're seeking a waiver, a variance, or whatever else it may be, you are acknowledging the fact that there is in fact a redevelopment ordinance in place. An ordinance which your governing body, your legislative body, obviously spent many, many, many hours in consideration. Many, many dollars to professionals, be they engineers, attorneys, and many other people, planners and the like. The language of the redevelopment ordinance is crystal clear. It says on Bodmin Place, there can be 2 driveways. That's what it says. Mr. Warkin wants to make the argument that, well, we were saying we want to have 3 driveways and we want you to grant the relief to allow that to happen. And I'm saying you don't have the jurisdictional power to do that. It's no different than whatever organization we're talking about. Everybody has a set of rules. Mr. Lechstein and I, for the past 30 years, have talked about baseball. Well, there's a set of rules in baseball. And there's only a certain authority that can change those rules. Not any planning board or zoning board or whomever it may be. And because a particular team doesn't like the fact that they're entitled to only 4 balls rather than 5 balls, they can change it. Here you have something that was drawn by duly elected members of your population, your citizens. That duly elected group said, after countless meetings, 2 driveways. Didn't say 2.5 driveways. Didn't say under certain circumstances you can have more than 2 driveways. Said 2 driveways. But that also has an impact upon the nature of development. They might not be able to get the number of units that they want there because they can't satisfy safety concerns with regard to traffic. Also, if they only have 2 driveways on the entire site, when you look at the plan, by having this second driveway and the northerly end, you're bringing much more traffic down Bodmin Place. If the first driveway that this plan has were the only driveway, you'd be able to, I would submit to you, control the things that the governing body wanted to control. They wanted to control the number of units that would be there. They wanted to control the number of cars which would go up and down Bodmin Place. And one thing I agree with everything that the neighbors have said, Bodmin Place is a dead-end street. And I would submit to you very respectfully, one reason why the legislative body of the state of New Jersey, in creating this redevelopment zone, said only the governing body has the jurisdiction to change it. Now, you know what? If I'm misreading it, it's a very simple procedure. Send it back to the governing body and let them re-adopt an ordinance and make it crystal clear. Everybody, I shouldn't say everybody, I mean, Mr. Lechstein is complimented both attorneys on the arguments which they have made and the law that they've presented. It's not a doctrine argument either way. It's something which demands, I would submit to you, that this board send it back to the governing body and say, what did you say? Did you say 2 driveways or did you say 3 driveways? The one thing we're not considering here is the impact that this has upon my client who owns the parking lot, which is in between these two massive buildings and in between these two driveways. Basically, in many ways, you're depriving him of the ability to utilize the redevelopment zone because you're granting setback requirements, you're talking in terms of granting waivers with regard to number of parking spaces, number of driveways, which directly affects the content and substance of what's going to be in this building. And I think that my colleague, Mr. Rowley, very clearly pointed out, and I read it over and over again in his papers, and the more you think about it, it's absolutely true. This issue with regard to the driveways is part of the core concept of the redevelopment plan. This borough had years to develop this plan. And I'm not saying that that was not well-intentioned, but now we're attempting, not me, but my colleague, Mr. Warnke, is attempting to convince this board that despite the fact that they paid tens of thousands of dollars to experts, despite the fact that this was printed and whatnot and published in newspapers, they really didn't mean 2 driveways, they meant 3 driveways. Well, how does he know that? How do you know that? You simply don't. You just simply don't. And I have to take real sympathy to the members of the public who say that we knew nothing about this, because the way the state created legislatively these redevelopment zones, you didn't have to give notice to the surrounding property owners within 200 feet when you're passing a redevelopment ordinance. So they were never given the opportunity legislatively to object to it at the time that it was first passed. So now they come before this board, and as lay people, professionals say to them, you're a day late and $1 short. Well, you know what? They're a day late and $1 short because that's the way the legislative body of the state of New Jersey created it. But having said that, that's all the more reason why you should read the redevelopment ordinance in the strictest light. Because if you're going to deviate from it, you're really depriving them of having had the opportunity to argue against it in the first place. And if you grant these requests which they're making, you're taking away the basic rights that they have to object to something which they say will impact the value of their property as well as their way of life. So I'm saying there's a very simple solution to this. You know, there's something in the municipal land use law that deals where you're going to the zoning board asking for an interpretation of what a particular zoning ordinance says. Well, I don't believe with a redevelopment plan you can go to the zoning board for an interpretation of a redevelopment plan. The only place you can go is back to the governing body. So I'm saying to you, hitch up your suspenders, look everybody in the eye, and I would say assume the responsibilities of making sure we get this right. Send it back to the governing body. And I thank you for your time and patience.
Thank you, Mr. Gazarovski. Mr. Warnke?
Good evening, board. We appreciate the time and effort that the board has taken into hearing all the application. We thank the public for coming out. Obviously, there's some differences of opinion, but this is a public forum and this is the opportunity for the public to be heard, and we appreciate that they're out here and that they've got questions that they wanted to have answered, and that the board has taken the time to fully understand and look at this application and hear everything through. As to Mr. Gazarovski's statements, I think he's mischaracterizing what we've said. One of the points we've continuously pointed out is this is a overlay redevelopment area. The redevelopment plan talks about applications for redevelopment, for an application for development, which is a defined term under the municipal land use law. The standards are to apply to that application for development made by the developer. We've made an application for site plan approval. Our application, as Mr. Gazarovski is conceding, contains 2 driveways, which is the permitted number in the redevelopment plan. There are certain design waivers that we're asking for, but we've provided testimony indicating that they are actually better design alternatives. Or it's a hardship because the property has 3 frontages and the parking area in the front, this is the only logical place. The driveway design that we have come up with, we've had testimony presenting that is actually a better, safer design than just having one specific driveway. That it allows for the pull-through for fire trucks, school buses to get around and turn around. Some of the public comment was with respect to safety and how we're going to deal with school buses, how are the emergency vehicles going to access to and from the property. The driveway as designed allows for that turnaround, which currently they don't have. So this is a better design alternative than otherwise, than having just a single driveway. The fact that their property is a quote-unquote 3rd driveway, but that property is not part of this application. When it comes before the board, if they look to move forward and develop their property, they've got the right to choose whether or not they want to move forward under the redevelopment plan or the underlying zoning ordinance. We have no jurisdiction or ability to tell them that. They've got the ability to make that determination for themselves. They are an undersized lot for the redevelopment area, so they've come in, obviously they've got the right to try to move forward under the redevelopment plan and come up with a scenario where they're asking for different relief. And again, that's their right to do so. But they are clearly undersized, not anywhere near the minimum 2-acre size requirements, but if they come in for their own application, they can move forward and they don't need to move forward under the redevelopment plan. The underlying zoning remains in place. We don't own their property. We've got no right to try to take their property. We have no control over their property. Their property is not before this board right now, and it's not appropriate for the board to concern themselves with that. Mr. Gazarovski made reference that the neighbors, under the way the law works, they may not have gotten a notice about the redevelopment plan, but Mr. Gazarovski's clients did, and they didn't make any, they weren't here. I was at the public hearings with respect to the redevelopment plan. Mr. Gazarovski wasn't. If they had a concern and they thought, wait a minute, this could impact my ability to do something on my property in the future, they had the ability to come out to the hearings at that point, and they chose not to. They're coming to the party late, and now they're coming up with trying to create new issues where it's clearly the intent was the application in front of the board has to comply with those redevelopment requirements. I want to go back and just, again, the board, we've hashed this project over and over again, but again, there's been a lot of testimony and public comment from the objector and the public, but this application involves property that's part of a redevelopment plan. Mr. Gazarovski says the governing body has the ability to govern and come up with what they thought is the correct use for the property, and they did that with this redevelopment plan. We substantially comply with that redevelopment plan that we're here before you. I got yelled at one point for saying how much we complied that they didn't want to hear it anymore, but there are certain items that there are slight deviations, but they're design standards. And the redevelopment plan and the governing body, when they developed the redevelopment plan, specifically gave you the right to grant those type of deviations if the board felt it was appropriate. The case law cited by both Mr. Gazarovski and myself talked about, one of the cases was the Whedon case. There was a quote in there, it says, accepting plaintiff's contention that no variances may be granted from the provisions of a redevelopment plan would lead to absurd and draconian results, which is exactly what I believe if the board feels they cannot grant a design waiver for an application in front of it, and that needs to go back to the governing body, that's a draconian and absurd result. As noted in the Cox book, because it's difficult to fully anticipate the very particular bulk exigencies attached to each lot, it would seem appropriate to allow C variances to be heard as part of a planning board review of redeveloper site plans or subdivision applications. It is clear under the case law, it is clear under the redevelopment plan that this board has the authority to grant deviations from the redevelopment plan, a C variance or a design waiver, if it's justified. We've presented planning testimony from our applicants justifying the design waivers that we had requested. Again, we talked about the hardship with respect to the parking and the loading areas in the front area. The other one was with respect to lighting. We believe it was the most appropriate and safer design because there's some lighting spillage out near the frontage. And again, it was a safety issue, which we believe this was a better design alternative than permitted or anticipated in the plan. But again, as noted by case law and the treatise on this subject, it's impossible to fully anticipate every particular circumstance. And that's why I think the governing body said, you know what, I'm going to give the planning board the jurisdiction to let and hear some of these type of design waivers and C variances, much like they have given you that opportunity for every other site plan that you hear. They set what the zoning is. You guys are allowed to grant C variances, and you're allowed to grant design waivers. If in fact it's a D variance or a use variance, then it goes to the zoning board. In this case, since it's a redevelopment plan, instead of going to the zoning board, it would go back to the governing body. But for the type of issues that we're talking about now, it's clearly within this board's jurisdiction to do that. So again, when you go back to this hearing, this is a project that's part and in conformance with a redevelopment plan that the governing body believed was appropriate for this location. The borough adopted it in part to address its affordable housing obligations. We've signed a redevelopment agreement with the borough. We're providing 32 affordable units, which helps the borough meet its obligation. We've provided the testimony that's in substantial compliance. We believe this is a better design alternative. At this point, I can go through all of the various testimony, but I don't think that's necessary. We just want it to be clear. We believe this is the right project. The applicant has tried to work with the board, has tried to work to the neighbors. We've made certain concessions, and we'd ask for the board to act favorably at this time.
Mr. Lexstein, just a question. I presume you are familiar with Whedon versus City of Trenton, the appellate division case. Looking at the facts in this case, with respect to the issue of the driveway, at best, the best argument that could be by either side is that it is or it is not a C variance. Is that correct?
That's correct.
There's no question that the issue of the driveways are a D or a use variance, right?
That's correct.
So if that is the case, then I've read Whedon, I have it here in front of me, but wouldn't Whedon be pretty close on mark in terms of the board's ability to grant those technical waivers?
We have, in my opinion, we do have the jurisdiction right to do that. And of course, if we determine that it's a variance, we have to apply certain standards to find that they have merit, which according to the applicant, they've made those application. With regard to the driveways, if it's a design standard, their argument is that it provides turnaround and safety for the vehicles that would be servicing. So certainly, if that's the board's conclusion, it's the board who makes these decisions. But yes, we have jurisdiction, in my opinion.
Anyone from the board have any questions, comments?
A quick question. I'd just like to know where the traffic signal situation is from your standpoint.
From our standard, the applicant has signed the redevelopment agreement with the borough. We've also made representations to this board, which we will stand by, that the applicant will make an application for a traffic light at the corner. The applicant will fund that application, prepare all the necessary work, and process that application. For technical reasons, the borough needs to be the technical applicant, but because of the type of application that it is, but this applicant, 176 Riverside, will process that. If the application is approved by the DOT, the applicant has agreed to pay its quote-unquote fair share of the traffic light, but in no event less than 50%. If the fair share is higher, it'll be higher, but at the minimum, they're gonna pay 50%.
So Councilman, just to answer your question, maybe I can bring it back to focus. The mayor and council did sign the redevelopment agreement. That redevelopment agreement was specific and that is that if the board grants approval to the plan, according to the legal redevelopment agreement we have, at that point, if this is approved, the applicant must prepare the necessary application for a traffic signalization event. They can't do it in advance because it hasn't been approved. In addition, we, the governing body, if this is approved, legally have to submit the request to DOT, which presumably, I think I can safely speak for all members of the governing body, we would be happy to request a traffic light since we've been lobbying for it for a long period of time. So that's how the process works. They can't just go ahead and file the application because the governing body has to do it. Meanwhile, it costs tens of thousands, or perhaps closer to $100,000 for those types of technical applications to be made. One would not make that application if this approval is denied.
And thank you, Mayor, for that clarification.
Thank you, Mayor.
And I ask because from the very beginning, my overwhelming concern has been for the residents of Red Bank, the current residents of Red Bank, not the invisible ones that haven't moved here yet. And they're in a bad spot. They're in a bad spot right now. And to put another 210 units, and somebody estimated 300 plus people there, and suggest that there will be no impact on traffic is just fantasy. It's ludicrous, in my opinion. So again, my concern is with the people who are there now and what will be once this project moves forward. And we're gonna put them in a life and death situation. As a councilman, I can't, in good conscience, allow that to the residents of Red Bank, the current residents. And even their future residents. This is for the protection of your future residents, all right? Because they will then be a part of that massive traffic dysfunction at Bodman and Riverside. So, understanding the mayor's point, I get it. There's a process, and the process has to go step by step. But without that, I can't in good conscience support moving forward with this. Secondly, you make contentions that this will be good for pedestrians, but I see nothing that helps pedestrians cross Riverside safely now or in the future. I just don't see it. This is a very dangerous intersection. And you're suggesting that there will be bikes and pedestrians and people on this corner, pocket park, and it's just, it seems unsafe to me. It's just unsafe in every way. So please, I'd like you guys to be good neighbors. And I think you will be good neighbors. But part of that being a good neighbor is going to be stepping back and taking into consideration the livelihoods, the property values, the safety of your current residents and your future residents in this very congested area. So, thank you for this.
I agree with Councilman Ballard. This is a beautiful project, but I have concerns about the quality of life for people who will be living there and their safety. And the traffic light is, it's definitely needed. Without it, I just don't know how the traffic is going to move, how the people who live there are going to be able to safely get in, get out, move around. And for those who are walking, I can't even begin to see without traffic light how they could even entertain the thought of walking across those highways, those streets. So it is a beautiful project. It would be wonderful for the people who don't live here yet and the people who live here. But what good will it be if the quality of life, if it ultimately is dangerous quality of life for the people who live there or move there?
And I understand some of the board's concerns. However, these are off-site traffic conditions.
This is not the time. The board-
I thought I was given the
The
opportunity.
board is.
Okay.
Deliberating.
Yeah, deliberating now, not the time to
All right, so let's talk about the traffic light. That's the biggest issue. That's the elephant in the room. Go ahead.
Regarding Mr. Skeeper's list of things that he would like to see the board follow through with, which none of seem unreasonable at all, and I understand why, especially under construction. How does that get memorialized going forward?
If the board wants to make those conditions, I'm not pushing it to keep that there. If the board wants to make those conditions, there will be conditions in the resolution. Again, the traffic light is a problem, I think the mayor's about to address it, and that the law doesn't allow us to make these conditions.
I'm not referring to the traffic light as much as surveillance and just keeping an eye on what's going on there. Should under construction there be problems and whatnot?
Well, we could ask that usually those construction details are done in the development agreement, and we could ask to make a condition that the developer's agreement be amended to include those. And that's the way it functions.
Mr. Warnken, Dr. Costa had a question, or had a comment or a question associated with the cost of the traffic light. If you were to receive approval from this board, would your client be willing to pay 80% of the cost?
As of right now, our agreement is our fair share, no less
We
than 50%.
understand that, I think the question is, would he go 80% is the question.
I'd have to-
We know what his position
Well,
is.
they're behind you, so why don't you ask them?
This is squeeze.
100%. Take the whole thing. Take the whole thing.
It's something they can consider. I'd like to find out, let the board continue to go through, and if at the end there's a list of various concessions and conditions, and I'd like to address them all at one point instead of piecemeal.
Okay, fair enough. Other comments from the board?
I understand, but I just want to hear if there's other conditions addressed at once.
Personally, it's a nice plan. I don't really think the characterization as a monstrosity and hideous is accurate. There are concerns. Last meeting, there was a testimony about the park, and we heard testimony from the traffic experts. And there was a talk about how it was part of the Complete Streets plan, it's consistent with the Complete Streets plan. And I went back to the design guide, I can't figure out how it's actually consistent with Complete Streets. I have a safety concern. We're talking about design pebbles, but those pebbles are meant for people to sit on. By the time someone's sitting there, if there's an accident, that person's now run over. It's not actually a buffer. What are we going to do? How can we come up with some sort of design element, should this be approved, that will protect the individuals who will be utilizing that space? You give any testimony about how it's consistent with the Complete Streets design guide, I'd love to be educated on it because I couldn't quite grasp it.
While they're contemplating that, David, if you'll recall, in one of the hearings, I had raised that issue because I have seen similar design standards in urban areas, but not to the level of pebbles that look like they're seating areas. And I thought that there should be some sort of additional safety precautions that could probably be developed. I don't know the best way to do it because I'm not an architectural landscape designer, but the borough would have the ability to secure experts as part of that process. That is my concern, that if we go ahead with this, I happen to think that the location of a public place would be of benefit to other residents on the street. However, there would have to be some safeguards, which are done all the time in some of our northern neighbors that have developed similar places. But what I saw, I was not convinced was appropriate.
I appreciate your comments on that, Mr. Mayor, and I agree with you entirely. And since we have been talking about off-site conditions, we might not be able to talk about it, but we did get the traffic testimony, and that traffic testimony does directly impact that particular space on the
Agreed.
site.
Yeah.
And we do have to address that. And I'm you to answer, but
Well,
I
I think
appreciate
that this
your
is for
follow
our,
on that.
our deliberations.
Yeah, I
so
appreciate
the
your
board
point
thinks
on that,
about
Mr.
that.
Mayor. Thank
Because
you.
I think that that could be developed, but I think that we need some of our experts on our side to maybe make suggestions as to address our concerns and also accomplish what they want to do. But the Pebble side,
It's not enough, and I'm not an engineer or up to date on the best possible design standards. We heard from the objector's expert that ballards were not necessarily the safest mechanism for that particular space, and it would be a precondition on my end of that. Some sort of buffer would have to be created. It just isn't gonna fly, especially considering there were 10 accidents in 3 years on that corner. It's just too much.
I think as I've mentioned in previous meetings, I'm not happy with that location at all. I think the Red Bank Master Plan says that the physical character of open space should be preserved. It's one of the goals of the master plan. The obvious place, in my estimation, would be where it is now, where that big sycamore tree is, or London Plane, and those smaller oaks. That would be on a public spot, on a street that would not propose any danger to people standing there or sitting there, or enjoying the view of the river there. The fact that it was put there, to me, where they're proposing it, it just doesn't make sense, except if you want to, you can't build a building there because of a line of sight for the road. So they figured they wanted to put as much building as possible in every square inch possible. And then they couldn't put anything there anyway. So they put that there in spite of the fact that it's a danger to people. It's not consistent with the master plan, and it just will not look good. And so I'm kind of opposed to that location, period.
I also am concerned with that location, and for other reasons. When you have as many 2 and 3 bedroom apartments in a building as that will have, you're going to have children.
Yeah.
And
Yeah.
I see no place for children
Yeah.
in this particular plan. That is hardly a playground area. I would be hard pressed to allow a child to go there without at least 3 adults watching them. So I'm concerned about that particular area as well, but for, as I said, for a little bit of a different reason, because I do believe you're going to end up with children. And I didn't see, unless I missed it, any particular area that you could consider an area for children. You're not gonna have them up on the roof, you're not gonna have them, you are gonna have them up on the roof? A playground on the roof?
Not a playground, but there'll be amenities on the roof.
Jump off too. That's great, kids on a roof.
You're gonna put the dogs on the roof.
Yeah, that's
It's the
great.
second floor.
Good idea.
It's third floor.
I'm still not letting my 7-year-old grandson
On a roof.
on the second floor.
On a roof.
I mean, come on,
Come on, man.
where would be the,
You're mossing us.
do you want
Yeah,
to?
yeah, do you want to go through the comments first and
Nah.
respond at the end?
Nah, don't respond.
Let's get through the
Just
board's
leave.
concern, then
That's-
we can decide whether we're gonna vote tonight, whether we're gonna give you an opportunity to resolve some of the issues.
Well, that's why I wanted to hear all of the comments. So,
Right,
yeah.
okay.
Mayor, if I may just remit, it seems the majority of what is here right now is the safety and the concern of the traffic light. So are you gonna elaborate on it a little bit, the traffic light? I understand that to process the application for the traffic light to the DOT would have to be an approval of the application, and then they can apply. Is that how that works?
Look, my thought and my philosophy from day one has, whether this is built or not built, in my opinion, you need a traffic light at Bondman Place in Riverside. I said it 10 years ago. The former administration didn't want to hear it. The current administration, in my opinion, in informal discussions, is more receptive because they understand what's going on in that area of Red Bank by Middletown. And I've had the opportunity to speak to some legislators who would be very supportive of moving forward, as well as the county, because the county Our legislators in three districts are very familiar with it and are willing to support our application. And the governor's office is aware of the need for signalization. Now, the response by DOT is that one light will be too close to the other light. I have seen lights closer than the distance between the light at the bridge and the proposed light on Bodman in plenty of other towns in our adjacent 2 or 3 square miles around Red Bank, and yet DOT has approved it. So if we can go to the moon and get over the idea of being too close to the other light, we can synchronize those lights. And part and parcel of any such application, again, we need a light there whether this is built or not. And one of the reasons why the DNA moved down is because frankly they were getting sick and tired of that intersection. And I agree with the residents. I see it every day. The visibility coming out of there, especially at rush hour, is hideous.
Horrendous.
You can't see the traffic coming off that bridge, and if you don't,
Agreed.
as I said before, I crossed myself before I get to that intersection, and after I successfully navigated.
So it's almost like a catch-22, so how is that amended to, like, approval of condition, for one? Like, how would that work? And secondly, I think I agree with Mr. Welsh on some of the conditions that were brought up by the public during the phase of construction. So not that I would agree with all of them, but majority I would. We would have to sort that out for approval for condition, I think.
Well, again, I'm not a construction supervisor.
No.
You're more adept at that than I am. However, I have seen situations when even though actually the state will not permit access on Riverside Avenue.
Yeah, I didn't like that one, yeah.
However, don't forget, this whole site is going to be developed if it is approved. Consequently, the construction entrance can be designated by the police department with DPW as well as our engineer in an area that will have the least amount of impact on the actual street. It's a big site. It's over 2 acres.
Yes.
And it doesn't have to be an entrance at the end of the street. It could be somewhere where it would create less of an impact. And obviously, if it's going to be construction, the owner is going to have to make appropriate arrangements with the police department for traffic control as well as ingress and egress, because that's standard.
Yeah, I know in other applications, prior when I was on the council, that we made amendments to situations as such during other construction work through the borough, through the building department and the police department and fire as well. So, yeah, I would like to see what certain conditions those would be that have been brought up by the public.
Yeah, I think that the video camera, I think is, I don't know where that is done and what other sites in town we've ever done that. I mean, probably the biggest site right now is what's going on at the hospital in terms of all of their construction. That's never been imposed. And, I mean, we rely upon people to tell us if there are violations and we act upon it.
Right, understand.
So far, I don't know if we wanted them to see tonight.
Well, there's a bunch of other issues I think we have to talk about, so let's talk about some other issues. David, I know that you're gonna.
Yeah, I know. I actually addressed I've addressed them all the way through. We've heard excellent testimony. I think, we gotta get to we have heard the testimony that a traffic light as a precondition of approval is not something your client needs to agree to and will not agree to. Is that correct? So, sorry, is that still correct?
Reject them.
There was line on
I have no questions. I have all the information I need.
They're relying on existing law. I mean, law sometimes changes under right conditions, but right now the law is that we can't impose it on them.
But you can't impose it, but if they're in agreement on going forward with it, subject to the state approving it, then we're not holding a gun to their head.
Absolutely correct. So where I have it now is that the issues that maybe they have to come back and address are, one, do they agree to 80%? Two, are we going to go into the whole area, about that public area, as to safety, bollards, preserving that tree, making them move that down there? I don't know. I mean, that's what the board, what is it?
I would certainly like to see a revision on the public space at the corner to make it more pedestrian safe. In the unlikely situation where a car could jump the curb, which has happened there. And I think there needs to be some more thought placed on that. If you can't move it down the street, I'd certainly like to see a new plan where that is more pedestrian friendly.
The other issue, which is part and parcel of the light, is actually the pedestrian access way.
And again, when we get an opportunity, I think we can address some of your concerns.
Save it all to the end. Yep. The pedestrian, if a light is going to be contemplated, part and parcel of that light signalization would have to be a pedestrian crosswalk, safely navigating. It's essentially it's a very difficult. It's sort of a 5 intersection, but I think it's going to have to be limited to specific delineation. Otherwise, you won't be able to cover all of the streets. But at least by Bodmin to access Riverside, and that has to be part of the signalization of the light. And I don't know how that can be done, but I believe that probably one way to do it would be to navigate the 2 lanes into one as it approaches Bodmin, and then free it up as it passes Bodmin towards the bridge. But and also because it's so wide, part of that is going to have to be like an elevated island for people to cross, because especially with seniors, it might take them some time to get across, and those lights change rather frequently. So we've played with that, and it's going to be part of our Shrewsbury Avenue streetscape enhancement. So maybe we can talk to our planners about that.
And there's certainly a possibility at some point that if DOT does end up wanting to do the light, they might want a couple feet of the corner where you want to put the park. They might want to widen that egress from Bodmin onto Riverside Avenue at some point from a traffic standpoint. But my comments stand on the park.
So on some of the other issues, I think that the rooftop gardens and the rooftop apertura is, I think, appropriate for a building of this type. I think it permits the residents and visitors to have a view of our natural beauty. And I think including the pet component is perfectly appropriate. So I think that that's an added feature, especially with the rain garden and those added features that have been added on that. So I think I like that very much.
So I've got a question about the sustainable. What 4, maybe the borough engineer could answer this, what are the 4, or was it 5, I'm not sure, sustainable measures they took to allow them to have the high density that they have?
I don't recall those off the top of my head. Obviously, I did many applications on a given basis.
I want to say we were talking about
The lead
there was
standard was
the lead
one.
standard, there was solar. No solar? Bike parking, I remember.
Bike parking, the
Can I tell you?
the
what
transit,
The Zipcar, the ride share.
Zipcar, and the transit to the train station.
The LEED Silver equivalent, the bike parking, the car sharing service spots, we incorporated rain gardens, the stormwater design, and we had a shuttle for the residents to the train during peak commuting hours.
No solar.
I think we might have talked about it, but if it didn't get in the plan, it didn't get in the plan.
So it was optional.
Was it optional? I know we talked about it.
It was
optional.
optional.
Okay.
Yeah, I'm saying these, like putting a bike rack there is just, I think that's like a nothing burger. I know that other places have eliminated because no one used it. And so I think that it's my whole feeling about this thing. We're doing the absolute minimum.
Yes.
Minimum, the absolute minimum.
Pretty obvious.
I would have thought at least they would put solar, just to show some sincere accommodation. But nothing. I'm just, and everything they've done is, like I said, I still have a sour taste in my mouth.
want to clarify, or I was under the impression, Mr. Skeeper, and correct me if I'm wrong, it wasn't a matter of surveillance on the construction itself. It was that intersection during construction, so that anything that was coming or going had problems along the way, that we could monitor it and take action on it. Was I correct in thinking that?
Yes, sir.
That's, it wasn't more of a building department thing, right?
Yeah, that's fine, yeah.
Mr.
Go right ahead.
The mayor reminded me, when we talk about the dog run feature, there was a discussion about where the water would drain from the bottom of the dog run and where that would wind up, and that should wind up in the sanitary system.
We did, I made a mention of that to Mr. Herman, that that's where we would like it to.
Okay, I just want to make sure.
Yes.
Thank you.
So I guess the question is, are we gonna continue this and let them address those, the 80%, the safety design, those that seems to be the two very large, the light, how they were addressed it, and the safety designs for the corner, or can they move that area?
I can safely say that for me personally, I need to see a change on the corner with that pedestrian area before I would want to proceed.
I agree.
I would have to say, if everybody is not happy with what they have there now, and would like to see ballards of significant size or however it works, I think that's fair. And I think that's a concern every other board has, and I think that's something that should happen.
And if I can, that's an item that we can address. The applicant is willing to slide the pedestrian access around the corner at the bottom. I can bring our expert to come and testify as to how we can address that.
I think we already have a design for people to sit, and how are we doing on that 80%? Are they loosening up?
Again, we were trying to get the list of the issues.
Well, you pretty much heard it. So
Okay, if those are the issues, then we can take a 5-minute break and we can come back and address the items.
I think I'd want to see a plan for that corner.
Yes, it's not gonna be finished then.
I think.
We have a plan that we can show you this evening.
I understand, but it's not gonna happen tonight.
But you have a plan with you?
To show you where we can shift it.
Plan.
We do.
Then we'll take a 10-minute break.
Wait a minute, I have a question. The irrigation system. Remember, you talked about that, and you said because it's sustainable, you're not gonna irrigate it after a short period, and if the trees die, so be it.
And we agreed to extend the maintenance obligation.
They agreed to go to 3 years.
3 years?
Yes, we did.
And the irrigation?
No, they agreed to guarantee on the planting for 3 years. So if something dies in year 3, it is their responsibility to replace. That's what they agreed to.
Mr. Chairman?
Hold
on 1 second.
I'm sorry, one other quick question, of course, regarding the traffic light. Has anybody from the firm reached out to the DOT preliminarily, just to get a sense of where they are from you guys?
Again,
You can't ask a question. You can't ask a question.
Get a commitment.
Well, not even a commitment, but what do we have to do? Like,
again, we have to get through this procedure first to find out that we have that if this gets approved, to move forward to the next step. We've had our professionals look at the issue, and we believe we can make a good faith attempt and hopefully get this approved. But again, it's premature to go to the DOT until we get through this portion of the project.
But just to ask a question, like, what would we have to do? Like, parameters that you would have to, because I want the application to succeed, not a good faith attempt.
And we want the application to succeed as well, but we don't have a project that's premature. There's no project to go to the DOT with until we have an approval at this level. Then we can go, and then we'll move forward with the DOT quickly to take the next step. But at this point, there's no application to go to them with.
But just a question. There's no questions. Okay, I got you.
Quickly, Mr. Gazarovski, before we break.
I'm going to object to, at this point in time, my colleagues submitting a set of Plan C, which have not been submitted to the board prior to this hearing, were not given to me to review or have my experts review. And if he had these plans, isn't it kind of duplicitous to say at the very end, when he realizes he has a problem, now I'm going to produce these alternate plans? It's just simply not fair.
Well, we're gonna take a break regardless, and we'll talk about that when we come back.